Well, every Friday, Colorado's best attorney empowers us with legal knowledge we can actually use. Phil Harding has been practicing law in Colorado for 26 years. He is a super lawyer 6 years in a row. He's been voted one of the top 100 trial lawyers in Colorado 8 years in a row. He is an AV rated attorney, which is the highest rating possible. He's also a member of the Million and Multi-Million Dollar Advocates Forum. He joins us now for our Friday in the legal class here this morning. I know that you've been super busy all week. I'm glad you were able to make it here today because you've had depositions going on all week.
Yeah, lots of depositions. You know what I thought? I thought we would go over, because we have this law school for the layperson, go over the legal process, and I would go over what a deposition is, all right? So I want to talk about that, and not only what about depositions, but let's say right after an accident, what statements you should make, what you shouldn't make. That's going to help you as you go all the way up through a deposition, or even if you go to trial.
All right, so let's start with the deposition. You're going to break that down for us, what that is exactly.
Right. You know, deposition, most people haven't gone through, so I want to talk about that. Deposition is a statement under oath, and actually testimony under oath before a court reporter. And this court reporter takes down everything that's said in the room, so only one person can talk at a time. It can be used in court. It can be used to impeach you during this deposition. The other side, and also your attorney, may be asking you questions about exhibits. They may even go over statements that you made right after the incident.
All right, so bringing up those statements, I mean, those usually come up right after you've had some sort of incident. I mean, someone calls you and they want to take a statement, right?
That's right. That happens a lot. And, you know, we go over this every once in a while, and I think it's good for our viewers to know and look at. First of all, you need to know who you're giving a statement to. With your insurance company, you have a duty to cooperate, but, you know, you can still have an attorney on the line. The other side's insurance company, remember, they have two jobs: protecting their insured and making money for their company. So do not make a statement to the other side unless you have the attorney online and the attorney says, let's go through it. In fact, I want to go over the law that says the other side really can't even take your statement within 15 days of the incident. And here's the law, Colorado law, CRS, that stands for Colorado Revised Statutes, and it says if a person is injured as a result of an occurrence which might, doesn't say does, but might give rise to liability, and said person is a patient under the care of a practitioner of healing arts or hospitalized, no person or agent of any person whose interest is adverse to that injured person shall, within 15 days after the day of the occurrence, obtain or even attempt to attain a statement. That's how strong the law is.
Do you find that they try to break that law, though, and call you before the 15 days?
Oh, all the time. Look, and they pretend like they don't know
This is why he's teaching us, so you can say, no, you can't call me.
Yeah, and I
know
the statute. As a matter of fact, that statute even goes through. That was sub C that we looked at. Sub A actually says you can't even settle your case within 30 days.
That's awesome. This is good stuff. All right, so back to the depositions. Are there right ways and wrong ways to do a deposition? Can you give us some tips on how to handle it?
Yeah, great.
Have to do it?
We have a graphic for this as well, and I want to talk about it. So here's tips not only for a deposition, but if you're making a statement. First of all, I tell my clients, don't try to win my case at the deposition. Don't try to win your case when you're given a statement, because the more you explain, that means the more you have to hide. I want you to think before you answer, and the reason why is because if you repeat this question in your mind, your attorney might object, and that's going to give it an opportunity. Keep your answer short. If you can answer with yes, no, or I don't know, do that. Also, never assume or guess. If you're making an estimation, right, like how fast is someone's going, just say, I estimate it's about this fast. And finally, be honest. That's the most important thing.
Okay. So, you know, once you go through the deposition, how is it going to be used at that point? I mean, where does it go?
Yeah, that's a great question. Hey, deposition, since it's a sworn testimony, it can be presented as evidence to a judge even before you go to trial. So if you have strong enough, unrefuted evidence, you can take this deposition, you can give it to the judge, and it's called a motion for summary judgment, and you can say, we win. We already win. We don't have to go to trial. So you can use it for that. The other thing that you can use it for is, let's say I depose the other guy. He's at trial, he changes his story. I then bring this out. I say, you remember when we had your deposition 6 months ago? Your testimony is this. Now it's something different. Once a jury sees that, I got to tell you, it's game over. They sit back, they rock in their chairs, and I know that I've won. So that's why you want to be honest, because you don't have to remember the truth. It's always the truth. It's just so important to kind of go over these things, think about them, know about depositions, know about making statements, know about the laws, and just follow them.
Okay, so, you know, we're learning about the depositions today, but let's do a little, you know, refresher course, because you come every week and give us some really great ideas. The whole thing about the statement, again, I think that's worth going over just one more time. You don't have to talk to anybody for 15 days?
Within 15 days, and then if you do give a statement, or if you are in a deposition, one last thing, you ever play hot potato?
Yeah.
Okay.
Yeah. You want to get rid of it, right?
Yeah.
Yeah.
Think of a question like a hot potato. Someone throws it to you. You don't freak out and drop it, right? You just quickly and accurately get rid of that hot potato. Same thing with a question. Quickly and accurately get rid of it. That's the way it should be done. That's the way you should view it.
Love it. All right. That was fun.
It was fun.
Yeah, I enjoyed this class. Thank you very much, Phil.
You're
We
welcome.
appreciate it. And if you have any questions for our legal expert, Phil Harding, just go to kwgn.com, click on Colorado's Best. You're going to see Phil's photo there on the right. Just click on his photo, and then you can send him your questions directly. He takes the time to answer them each personally and confidentially. And to reach Harding & Associates directly, call 303-762-9500. You can also get a free consultation anytime. Just check out his website. It is hlaw.org. Well, coming up on Colorado's Best, Beat the Heat. Colorado's